Perfect. Thank you for that, Bruno.
Cool. So Nick, yours. This is a big one. All right. Now, in a rental, so this is a rental instance, and this is a question that's asked by an agent. In this particular situation, the old tenants had to move out the property. There were new tenants that were supposed to move in. But this all happened simultaneously to the point where the new tenants actually assisted the old tenants in moving out. So you can imagine like all of this happening, somebody's moving out, somebody's moving in. You've got this rental agent just trying to juggle these balls and make sure that everything goes smoothly. Nonetheless, all right, now this happened and there was an inspection. There was a single inspection. But this inspection was done all at the same time, so it counted as the outgoing inspection and the incoming inspection. And this agent is convinced that they had a signed incoming inspection. They just can't find it, right? But they're convinced that there was an inspection that actually took place. Now, this was like 3 years ago. Everything's been fine since then. Then there were some inspections that were supposed to take place last year, you know, as often happens where you just want to double check that the property's in good order. At this stage, the tenant did not allow the inspection to take place. Now it transpires that there's mold on the property, and the tenant hits the landlord and the agent with a 1-month notice and refusal to pay rent on the basis that the property is not habitable because of the mold. Right? Now, comes back down to that, to those questions around how do the inspections work? What happens if they weren't signed? What happens if they weren't conducted? What happens to the deposit, right? So we've got the inspection conversation. Then we've got the damage conversation, which interestingly enough is also around, well, can a person, for starters, refuse to pay rent in the case of mold? Assuming, of course, it's a serious case of mold and a person can't actually stay there, which does happen. Can there be a rental remission or refusal? And is the person entitled to simply give notice and move out? So very generally, Nick, what would a person be looking at in these instances?
Perfect. So we'll touch on a few things, but what's really important with regards to this question is the inspections of a property and some deeming provisions that are applicable to rental agreements in terms of the Rental Housing Act. So just for our landlords out there, for our agents out there, please remember Section 5 of the Rental Housing Act is a very important provision that has to be kept in mind when dealing in this industry and dealing with tenants. And Section 5.3 specifically has certain deeming provisions that are deemed to form part of a lease agreement within our law. Okay. And this deals with a whole bunch of things, but specifically for the purposes of this question, it deals with entry and exit inspections and what are expected of a landlord or the agent acting on behalf of the landlord and the tenant must do in the particular circumstances. So firstly, in terms of this question, we'll deal with entry inspections. So entry inspections are something that the deeming provisions in the legislation require to happen prior to the tenant moving into occupation of the premises. So the landlord and the tenant are required to perform an entry inspection in terms of the legislation so that they can figure out what damages are on the property, if any, and what is going to happen with respect to those damages. The legislation does not require the landlord to attend to anything at all. Okay, it just says you must determine what condition the premises are in and figure out what you're going to do about it. And this has to happen before the tenant moves into occupation. On the other side is another provision which requires that the landlord and the tenant 3 days prior to the expiry of the lease agreement conduct an exit inspection to figure out what the condition of the premises are at the time that the tenant is vacating the premises. And this is so you can determine what needs to be fixed up, what is not being given back to the landlord. Remember, in materially the same condition that the premises was received in, fair wear and tear accepted in the circumstances. So if there's damages or anything, that is why a landlord can use the deposit towards those particular amounts. Now, this is absolutely the circumstances that we have here is a very common thing. It's a little bit tricky where you've got a tenant moving out, you've got a tenant moving in the circumstances, and you've got to try and handle these, both of these tenants and make sure that you comply with both of them in terms of the legislation and the circumstances. But in terms of our question, our agents told us they did do an entry inspection, and this was sort of simultaneous with the exit inspection of the previous tenant, but now they can't find the signed entry inspection. Now, the good part of for this particular facts of in our case is it is not a requirement that the entry inspection is signed by the parties for validity. It is required that the entry inspection is done in the circumstances, and that it forms an annex of the lease agreement. But as long as that happened, whether it was signed or not is not going to be a material error in this particular circumstance. So the agents told us they still have the entry inspection, they just don't have a signed copy. Absolutely not a problem. The entry inspection was done, and so the premises will be deemed to be whatever's sitting inside that particular entry inspection in the circumstances. On the other side, so the consequence of failing to do something like an exit inspection is also contained within Section 5(3) of the Act. And this is why if you're an agent acting on behalf of a landlord, or if you're a landlord dealing with your own property, you need to be very careful, because what the provisions of the section say is if you fail to actually perform this inspection at the end, okay, and actually check the property is in good order with your tenant, or failing your tenant coming and actually coming to do the exit inspection with you within 3 days of the expiry of the lease agreement, you are entitled to unilaterally go and do it at the end within 7 days of the expiry of the lease agreement. But if you fail to do either of those things, there is a deeming provision in the legislation, which is more of a penalty for the landlord, in that it deems that the property will be in good order on behalf of the landlord in the circumstances. So you cannot, as a landlord or as an agent, fail to do the exit inspection either with the tenant or the landlord afterwards. You can't fail to do it and then at a later stage decide, fantastic, we are going to go back, and now claim damages against the tenant. The tenant will have the ability to rely on the legislation to say, no, there's a deeming provision that the property was in order and you didn't comply in the circumstances. And that can prevent the landlord's ability to utilize the deposit for the damages on the particular premises. So this is very important for a landlord to keep aware of this. And if you're an agent, even more so, because you have the responsibility to make sure that you don't prejudice your client, being the landlord, from their ability to use the deposit. Now, remember, just another thing with regards to the deposit. Deposits are used generally for damages on a premises. That's what their intended use is, okay? But that's not their only use. Deposits can be used for anything which might be outstanding, owing by the tenant to the landlord at the end of the lease agreement, okay? So even though there's a deeming provision with regards to the state of the property at the end of the lease agreement, that does not preclude the landlord from utilizing the deposit to pay, for instance, rental, which has not been paid on behalf by the tenant to the landlord, or if there are outstanding utilities which have been levied to the tenant that they haven't paid. So the deposit can still be used for those particular things, and this deeming provision is not going to affect those claims. The deposit can still be used there. But it might be a case that the landlord cannot say the property is not in good order because of the deeming provision that exists in legislation. And then lastly, just with regards to this particular question, so we've been told there's an entry inspection that was done, and now at the exit, there is a mold problem. So the tenant has been in occupation for a period of 3 years. There's now a mold issue, and the tenant has given notice, said that the property is uninhabitable as a result of the mold. Okay, but this seems like a factual question in the circumstances. The entry inspection is done. There's no mention of mold. The parties don't have a difficulty with that, and the tenant has occupied the premises for a period of 3 years. We've been told that the question of mold has never come up during that 3-year period. And now, at the end, the tenant has decided, okay, well, there's a mold problem, and they are giving notice to move out in the circumstances. The problem with this is, for all intents and purposes, obviously this will depend on the facts of the particular case and what the parties can demonstrate, but it seems clear to me that that mold has come up as a result of the tenant living in occupation of the premises. So remember, the tenant's obligation is to hand back the premises fair wear and tear accepted. Growing mold in the property is, obviously it's not there at the commencement. If there is excessive mold at the end, that's not fair wear and tear. You cannot say that it's fair wear and tear that mold grows in a particular property. The property is not being used in the way that it should be, or something has gone wrong, which has caused the mold to grow in the circumstances. And so that is something that you can absolutely hold the tenant liable for in the circumstances. Because it's not going to be acceptable that they allowed mold to grow in the premises while they occupied that premises for a period of 3 years. And then lastly, this tenant has, obviously what they've done is they've said, well, I'm going to unilaterally decide to withhold my rental as a result of the mold that is growing in the particular premises. Again, unilateral declarations within agreements are never really something that are acceptable unless it's something that has been set out specifically in the lease agreement. You as a party to a reciprocal contract cannot decide to just withhold your performance at some point. Okay, so you can't just decide, I'm not going to pay you the rental for last month because now there's whatever issue. That's not how contracts work in South Africa. Even if there is a breach of an agreement in contract law within South Africa, this would generally require a notice, a form of breach, a breach notice, a letter of demand, a mora letter saying that the other party is in breach of the agreement, and then setting out what remedies they intend to use in the circumstances. So please be very careful where someone tries to unilaterally withhold their performance. There are very rare circumstances where that would be allowed, and almost only would it be in circumstances where that is specifically codified within the agreement between the parties.
Awesome. Thanks so much, Nick.
Perfect. Thank you,
Cool.
Bruno. And we will see you next week.
Awesome. Have a great one.
Good one. Cheers.